So with no further ado, I will hand over to Debbie. And thank you again for joining us.
Thank you very much, Laura. It's my pleasure to be on this call with all of you. Recently, Laura attended an ICC meeting in Paris, and there was a presentation on the Singapore Convention. And what she reported was that there were a number of people in the audience who hadn't a clue what the Singapore Convention was, and why it was even developed. Ergo, we figured that especially in this time right now, where everybody is working remotely, that it might be timely to talk to people about the Singapore Convention and how it will change the future. In a way, what we want to do is frame everybody's expectations about the Singapore Convention and what it really means to them. So what we're going to talk about today is what led up to the Singapore Convention. Why is it even needed? A convention for the enforcement of mediated settlements that parties voluntarily agree to. That sounds like an oxymoron, but in fact, there was a lot of question about whether or not there was a need for the convention. So I'll talk about what the real need is. I'll also talk about the progress that's been made since UNCITRAL adopted the convention. And we'll talk about what that means, again, to people who will use it. And then we'll talk about the future. What will the future look like? And I'll invite people then to add their comments and questions. One of the issues that arose in the Working Group 2 meetings was there's no evidence that parties were walking away from mediated settlements. So, there's really no need for a mechanism to enforce settlements. I think that they were looking at it really in the opposite way. There was a lot of evidence from corporate users, especially in the global context, that they weren't even able to get past go. They couldn't get the other side to use mediation because, face it, in the international context, everything is done in the shadow of international arbitration. People were very satisfied with arbitration, although they were complaining that the costs related to arbitration was increasing. But even the arbitration community were finding ways that parties could use mediation, but go back to arbitration to enforce their settlements. So, what parties were looking for was a mechanism to reduce encourage of Queen Mary studies that mediation was a voodoo process. So, the global companies were looking at it a little differently. They were looking at increasing the use of mediation so that their transaction costs would go down, number one. And number two, that parties could use this process effectively with confidence, and that people will just motivate or look at mediation in a much more serious way than they were today or before. So what happened? So the Singapore Convention, or the Convention for the Enforcement of Mediated Settlements, was adopted by UNCITRAL in December of 2018. In August of 2019, there was a signing ceremony in Singapore for the convention. Over 54 countries have now signed on to the convention. But what's the difference between signing on and making it effective? Well, under the terms of the Singapore Convention, 3 countries had to ratify the convention before it became enforceable. And in fact, as of this month, we had the 3rd country sign on. So within 6 months, the Singapore Convention becomes operational. What does that mean? Well, what it means is that if you have a dispute involving parties who are in the 3 countries who ratified the convention, and there's Singapore, Qatar, and one other country, that you could elect to use the Singapore Convention to enforce the settlement. There are challenges, though, and those challenges are the fact that many more countries need to sign on or ratify the agreement before it becomes widespread, has widespread use. The big challenge is that there's a whole block of countries in the EU who have yet to actually sign on to the convention, nonetheless even adopt it or ratify it. There are also countries in South America and Africa who are looking at the convention. They may not have been very active, but they are looking to change their economic viewpoint. So they're trying to tie the ratification of the convention into into how their economy will evolve. Today, with a lot of economic development halting because of the coronavirus, we're going to see even more challenges. There will be many disputes involving supply chains that have been broken. And individuals who are involved in those disputes are going to want to find the fastest way to get back up and running. And they can't rely on the court systems or on arbitration to resolve those disputes. So they're going to be looking to mediation, and they want to be sure and confident that if they use mediation, that their cases will be not only resolved quicker, but that they can be enforced. So this is going to be a real big challenge and an opportunity for the mediation community. What will the future look like? We think that that there will be, greater confidence in the use of mediation, as I've said a few times, and less reliance on arbitration. Prior to the Singapore Convention being adopted, many organizations adopted rules that would integrate both of the processes. So Singapore has an ARB-meet-ARB process. The future with the Singapore Convention would have less reliance on having to go back to arbitration to gain the confidence in the resolution. We're also going to have to come to grips with having a better understanding of what mediation means across cultures. What we've found through the Global Pound Conference and other studies is that cultural uses of mediation differ from country to country. Not only do those cultural differences define the processes in their own countries, but how the process is used. In some cultures, the mediator really is an evaluator and decision maker. In other cultures, the mediator is basically a facilitator. In some cultures, when they say mediation, they're really looking for the mediator to resolve the case. So we have to have an understanding of what the cultural context is and what process is actually being used so that we can be successful in that culture. In going through this process, I think that we have to be careful not to impose our own cultural framework on mediation, of mediation onto another culture, but we need to understand what their needs are, what everyone's needs are based on their cultural orientation, and adjust the mediation process so that it meets the cultural needs of the people involved in the dispute. We also determined through the Global Pound Conference that the future of dispute resolution will be the mixing of modes. Today, people look at mixed mode in the context of ARB-MEAD or MEAD-ARB. What is that? That's where a mediator or an arbitrator changes hats and becomes, so for example, an arbitrator changes its hat and becomes a mediator, or a mediator changes their hat and becomes an arbitrator. It could also be one where a mediator refers the case to another person who is an arbitrator, or an arbitrator refers the case to another person who's a mediator. There's also what I look at as a very difficult conversation that must be had, where an arbitrator and a mediator are selected to resolve the same case. Should there be communications between that arbitrator and mediator during the course of, excuse me, of the dispute resolution process, and what would be the parameters of those discussions? I am co-chair of a mixed mode task force that was a result of the Global Pound Conference. And my fellow co-chairs are from the College of Commercial Arbitrators and Pepperdine Dispute Resolution Program. We have a group of over 100 people who are grappling with the different nuances of mixed mode and what does that mean. You should always keep tabs on the IMI website for developments in what the mixed mode task force is doing. And you will see that the future of dispute resolution might be very different than what we have today. As I mentioned earlier, we want to encourage economic development through the use of mediation. And I think that will actually happen through the process that we're looking at today. Education. As I mentioned early on, Laura was at a conference at the ICC, and people had no knowledge about the convention. What this really told us was that people need to know and understand, excuse me, what is mediation and the ramifications of a convention. And it really is incumbent on all of us in the mediation community to reach out and undertake this education. It also means that mediation is reaching a point where it's no longer something that people dabble in. It's becoming a profession. Mediators will be sought after because of their professionalism. And in order to maintain that professionalism, they should have a code of conduct. And that code of conduct really dictates the integrity and confidence that will be needed in the mediation process. IMI does have a code of conduct, but we'll be looking at it again, as we did a few years ago, to ensure that it meets the evolution of what's happening in the mediation world. So now I'm going to turn this over to all of you who are patient listening to me to give your 2 cents. What else will happen? What do we need to do in our individual countries to prompt them to adopt and ratify the convention? And, how can we expand the use of mediation globally? Those are just 2 of the questions that I teed up, but I'm sure you have many more.
Perfect. Okay, thank you very much, Debbie. So if anyone has a question, I believe you should have a button on your Zoom to raise your hand, and then I will unmute you. Alternatively, you can put a question into the chat, and we'll answer it for you there, or of course, any comments as well. Okay, so Ivana has a statement more than a question, but hang on, I've got Natalia has got a question, so I'll allow you to talk now. Please just introduce yourself and where you're from, including your country, and then go ahead. Natalia?
Hello?
Hello. Natalia, did you have a question?
Yes, in Ukraine we have prepared a draft law on ratification of Singapore Convention, and in Ukraine the decision is to change the civil procedural law. Though the question is what are the standards of mediations, what are mediation rules to be taken into account by judges. So the question is whether, how do you think, what are the standards, the ethics of mediation to be taken account by judges?
Well, I guess the way that I would answer your question, Natalia, is that IMI has model mediation rules. Remember that mediation is very different than arbitration and a civil proceeding. A lot of the processes are framed or adjusted by the parties themselves, although there are certain standards that that are embedded in the code of conduct to ensure integrity and confidence. So, for example, one of the major principles of mediation is that the process is confidential, to allow parties to provide the mediator with information that they could help use to allow the parties to settle. This is really a foundation and a real cornerstone of the mediation process. I think that we have to educate the judiciary as well as legislators, people in your Congress, about the difference between mediation and arbitration and the court proceedings.
Great.
Thanks.
Okay, looks like Ivana has, oh, I unmuted the wrong person. Ivana has a question as well. Ivana?
First, hello, do you hear me?
Yes, perfectly.
Perfect. First of all, hello everyone. It was wonderful to attend this seminar. I would just like to have, I did have let's say a comment on, I would like to expand on what Deborah mentioned, that this situation that we're all facing now, the coronavirus outbreak, is a potential opportunity for mediation, as courts are closing their doors, and essentially now, yes, certainly there will be more and more disputes happening because of the virus outbreak, but it is a potential opportunity for mediation because it can allow for online resolution, and in that way it would be useful for IMI maybe to expand on, to promote existing let's say recommendations and all the knowledge related to the way online mediation can be conducted, and perhaps to work on that, because it's really something we can tap into. And another point or question more, coming to what Natalia said, it would be useful for, I think, countries, as I myself, for example, am working on the ratification process in Serbia, to be more and more aware, to have more knowledge on how other countries are implementing the convention into their legislation. So currently, at least what I have been able to research, the Singapore bill is online and in English, but there's not a lot of knowledge shared on what the other countries are, how they're preparing to implement this legislation and the new enforcement rules. So I think more knowledge on this would be useful for anyone working in the countries that will be ratifying to move this process forward. And certainly this crisis that we're facing currently might actually also promote this ratification process, because of course for courts to go online, it's a more it's a longer process and with many more concerns. So it's probably easier for mediation to go online, even in countries like Serbia, where it's not happening online yet. So just that. And thank you, Deborah, for a wonderful.
Yeah, thank you. Thank you for that, Ivana. It's very interesting. In the last month, I've had at least 3 invitations to attend a Zoom training to learn how a mediation can be held through Zoom. And there's been a lot of discussion of online. And you're right, the courts are behind. They're not. They're really not implementing online mechanisms. I think part of that is judges hate to lose control, or that's how they see it, that they'll lose control. But this is opportunity. And maybe Laura and I can work on expanding the webpage that the IMI has on the Singapore Convention to link to how countries are actually implementing the convention. It's probably easier now for us to jump on that because of the fact that there are only 3 countries that have ratified it. But that's something that we should undertake. Thank you.
Thank you.
Okay, thank you, Ivana. Thank you, Debbie. We've got some questions here from Hu Yi, who I believe is based in Singapore. He would like to know, he says that for SMC, letters are sent to parties in the midst of Singapore High Court cases. Will this be done by, he said Sydney, but I assume IMI as well? And is there a possibility with similar partnerships with courts overseas?
The letters are being sent to them. What do the letters say? I'm not clear.
He hasn't said, and he said he's got quite a hoarse voice, so it's difficult for him to join the call. But I'd just like to clarify to Hu Yi actually that IMI are not a service provider, so we help promote mediation, we help develop standards, people can become certified with IMI, but we don't provide mediation services ourselves. So I think that might be a bit of a point of confusion. But I'll come back to you while we wait for those clarifications. And in the meantime, I can see Veronica has her hand up. So Veronica, if you'd like to go ahead.
Yes, thank you. Thank you very much for hosting this webinar. It's very interesting. And I'd like to go back to what Deborah said at the beginning about the EU countries. And I am actually trying to research more information about Singapore Convention on Mediation, and I cannot find much information why EU countries don't want to sign the Singapore Convention, or why they haven't signed it yet. Could you tell me a little bit more if you know something about it?
So yes, thank you for that question, Veronica. During the course of the discussions at the Working Group 2, the EU representative was very, very active in the discussions and in the formulation of the Singapore Convention. In fact, he was instrumental in having the EU adopt not only a convention, but model rules, so that countries who use model rules could adopt them versus a convention. This goes back to what I was talking about regarding understanding the cultural framework of individual countries and finding a way to adjust and integrate mediation based on their culture. So it was very, we were very happy in the end that the EU representative did adopt or did vote in favor of the convention and the model rules. Since that time, there's been a lot of negotiation within the EU. First, what they want to do is make sure that the convention does not contradict or otherwise be inconsistent with their own rules. Remember that the EU has its own proposals on mediation. So, they want to make sure there's just no contradiction or conflict with their own rules. And secondly, my understanding is that they're trying to determine whether to have the individual member states of the EU adopt or ratify or sign the convention separately or in conjunction with the EU. Those discussions have been ongoing and have not come to a resolution as far as I know. And I suspect that with the coronavirus, some of those discussions have stalled. But we are encouraged because we do know the individual states are excited about the convention and the model rules, and I think that a lot of them would go ahead and adopt them. But I think that there is a political issue with the EU that has to be satisfied first. And then we can't overlook the fact that the EU and Great Britain have been working hard on Brexit for so long that when Brexit occurred, all of their attention was really on Brexit rather than these other issues. So now that Brexit has occurred, hopefully, things will accelerate.
Thank you very much.
Perfect. So if there are any more questions, you should be able to raise your hand on Zoom or put in a comment and I'll call upon you. While we're just waiting, I mean, Debbie, what do you think is the answer to customizing sort of mediation to different cultural needs, which you mentioned is one of the really difficult parts of implementing the Singapore Convention?
Well, I think education is the key. Remember that IMI has intercultural standards for mediators, so that mediators who enter into a mediation where the participants come from different cultures, they encourage, not only encourage, we require that under these standards, that the mediator not only understand the culture of the participants and any witnesses who might come into the mediation process, his or her own cultural context, because sometimes without that understanding, culture can conflict. So it's an education process. I know in my own teaching, I try to sensitize the students to these cultural issues. So for people who are getting a law degree, they're probably much more attuned. We need to expand that to the business community.
Great, thank you. I've just got a comment here from Lena, who is just talking about the possibilities of mediation in terms of resolving the coronavirus issue, or at least addressing it, which I think also comes to play with what Ivana was saying before. So Lena, would you like to go ahead?
I think I was just kind of proposing that maybe that would be the possibility to set up somewhat of a, sorry,
That's okay.
a network. It wouldn't have to be, maybe just a loose one, like maybe even just through IMI, maybe that mediators or young mediators that would be willing to engage in that sort of activities could sort of sign up and then be addressed. Because I was thinking that before as well, that I think right now, since a lot of families are sort of, you know, locked in together and spending a lot of time together, and I think that makes a lot of conflicts surface that maybe in other situations wouldn't, and also make new conflicts come up. And the same thing on a business level. I think that maybe this brings up new challenges which could lead to conflicts. So I guess, well, there could be quite the need to maybe have mediation assistance. And I was thinking, since I'm a young mediator with not that much practical experience, this could also be a chance to include mediators like me, and maybe even offer pro bono work.
You know, Lena, that's a great idea. We in my household, I could say we're intergenerational. My son, who's in law school, is now with us.
Mm-hmm.
And you know, every now and again there is a dispute within the household, and sometimes you could use professional help on having you know, diffusing some of those tensions. And I think that's a great idea. Maybe we could develop a chat room and invite people to access it, to get assistance from individuals like you. What also came up the other day in a press conference with Donald Trump, for those of you who are not aware, and I hope everybody is aware, China and the United States entered into a phase 1 economic agreement. And one of the questions that arose was, is China going to default on the terms of the phase 1 economic agreement because of coronavirus? And the president basically said, no, they're not. They haven't. Where, you know, supplies are coming through. But I think that there is a logical, you know, you can make a logical step by saying, yes, there will be disputes where supply chains would be broken because of the coronavirus. Paul Mason, is he on the line? Because he has already anticipated these types of disputes in Brazil and has written an article on it. I don't know, Paul, do you want to speak to it? Laura, is he on?
I've just checked. He doesn't seem to be online, but we can. I'm going to invite him probably to speak in a couple of weeks as well. But in the interim, people can also check out the article about the Singapore Convention in Brazil, which is published by the IMI website. So feel free to just drop me a line or drop me an email if you can't find that link.
I think that shows that there's going to be a lot of upcoming, potential at least for upcoming disputes on all sorts of levels, on like a very low threshold level, as in within families and households, and then on business level and on political level. So maybe, I don't know, what just came to my mind could be something like adding a section also maybe in like the IMI search engine. I don't know how technically that's possible. I wouldn't know, but as in like that you can click yourself available to be also for online help or something like that. And then that could be something that could be, I don't know, maybe published or something.
That's a great idea. We'll see.
Yeah.
We'll see how we can implement it.
Thanks, Lena.
Thank you.
I'll look into that. Great. We've also got a question here from Susan Andrews, and she asks, if one is a facilitative or transformative mediator and prospective party clients are cross-cultural with varying mediation style, tendencies or preferences, how best to navigate the disparity you describe if they are interested in one's services?
Well, I think that the best way is to, before the engagement starts, explain your approach and ensure that they understand your approach. And then as the process ensues, I think that it's then incumbent on you to have a check at different points within the process to make sure that the parties are still on board with the process that you're delivering. It's also an opportunity for you to educate parties on how the process that you deliver may be very valuable and workable for them. You know, oftentimes parties have this frame that they only want an evaluative mediator without understanding that even within the facilitative style, there is some evaluation going on. It's just that the mediator is not telling the parties what their position is, but helping the parties understand their own dispute to come to the same point. So it's really a matter of a continuing education before and during the mediation process to increase that level of understanding. I hope that answers your question.
She says, exactly my approach initially, and appreciate the further guidance on educating them. Excellent, thank you. Perfect. All right, thank you, Susan. All right, well, I think we're just about drawing to a close on this seminar. So if there are any more questions, now is your moment. Otherwise, thank you very much to Debbie, and thank you very much for joining us in the first of what we hope will be a series of seminars and webinars about the Singapore Convention in the months going towards ratification. I will be sending out probably a short survey after we close this